I'm glad to welcome you to our call today. This is Mark Poerio from Wagner Law Group. I'm joined by my partner, Bruce McNeil. I'm in D.C., Bruce is in Boston, and in New York we have Chelsea Mason, a principal with ClearBridge Compensation Group. We have really kind of an interesting dialogue to start because what we want to do is look at executive compensation from a broad perspective, generally from the side of what can you hear about today that would be a good idea to factor into your planning for the year ahead. And with that in mind, what we hope you'll do is look at the bottom right of your screen and see that you can submit questions during our presentation today. And we encourage you to do that if you have anything, because our goal here today is to get the dialogue going and deliver on the questions you have. In terms of what we're going to cover, we're going to start with observations about trends, new developments that we see in executive compensation, possible plans, either new ones or changes to consider. Then we'll move to talk about investor relation issues, followed by discussion of last year's Jobs Act, notably new Section 83I of the code, as well as changes, dramatic changes to Code Section 162M affecting public companies. In general, by the way, our conversation here and all of our comments are going to be equally applicable to public and private companies, but we'll note it when there are particular differences between them in terms of different considerations. Time permitting, we're going to talk a little bit about director compensation at the end of our call. And like I said, we're nothing if not nimble, so feel welcome to send your questions through the WebEx as well as by separate email to us after the call if that's easier for you. With that in mind, we'll turn to just a quick introduction of each of us. I'll start just because I've got the mic at the moment, but again, it's Mark Poerio. I've been practicing for almost 30 years, almost all in executive compensation. And for 10 years, I've taught at Georgetown Law School courses on executive compensation that look at a business, securities, accounting, tax, and employment perspective. So that's enabled me to generally cover the landscape in this field. Chelsea, we'd like to hear a little bit about what you do and your background.
Sure. Thanks, Mark. Good afternoon, everyone. So as Mark mentioned, this is Chelsea Mason. I'm a principal at ClearBridge Compensation Group, which is an independent executive compensation consulting firm. And we work with both private and public companies, trying to focus on effective incentive plan design, both annual and long-term, both for executives, for the broader employee population, as well as board of director compensation. And I've been with ClearBridge about 7 years now, and focused exclusively on those areas. So Bruce, maybe I'll turn it over to you now. You can tell everyone a little bit about yourself.
Thank you, Chelsea. This is Bruce McNeil, also with the Wagner Law Group. I've been practicing in the deferred compensation area for a long time. I've written over 34 books, most on non-qualified deferred compensation, but also mergers and acquisitions, 401k plans, and other employee benefit matters. I'm editor-in-chief of the Journal of Pension Planning and Compliance and the editor-in-chief of the Journal of Deferred Compensation, published by Wolters Kluwer. The books are generally published by Thomson Reuters, but other publications too, other publishers as well. So that's a bit of our background. Now I think we'll get back to you, Mark, on some new approaches here.
Yeah, I feel like a bit of a slug there, Bruce, by comparison to your writing efforts. But, you know.
Well, you can make anything up on this.
There you go. but I can tell you that when Bruce was mentioning non-qualified deferred comp, I feel like that's a really good start for what I think of in terms of what can be the newer and best approaches this year. And I mention that because you know, I feel like in an up market like we have right now, stock market, you see tremendous emphasis on stock compensation, both at public and private companies. And very often, a significant part of that comes in the form of stock options. For anyone who lived through the bubble burst in 2000 or the recession in 2007, you know that stock options that are out of the money can create, really havoc with the workforce. It's, saps the spirit of employees, and, having out of the money options has a lot of, downsides to it. So I mentioned that not to be a Debbie Downer, but just to say, it's a good time to be thinking of alternatives to stock options or better ways to structure. With that in mind, I feel like, what I would see going forward is a much greater emphasis, not just on performance awards, whether in stock, phantom stock, or just pure cash that's driven by some value other than stock, but also performance awards that are much more customized. In general, you'll see performance awards that might relate to EBITDA or one or two gap measures. But what I'm seeing in general, especially I would say in private companies and private equity-owned companies, will be performance formulas that are almost more siloed. They'll look at the particular division, the particular objectives for the operating group or the individual involved. And I think that does serve some significant corporate purposes, because the refinement of performance goals can provide both a significant upside as well as the downside, and give people a stake in the success of really what they're responsible for. One other thing I would say in terms of when I think of improving awards, it goes back to deferred compensation. That I think the employers I've seen out there who can be the most unhappy with their executive compensation are the ones who have paid very healthy performance-based bonuses on an annual basis. Oftentimes they've paid above market because they value the individual, and then they get burned if that person leaves to join a competitor or to take employees with them, or sometimes to take the trade secrets with them. Through these executive compensation plans, employers can build, essentially precautions that discourage those types of behaviors. And through deferred compensation, they can also give an upside related to the company, holding back shares or cash until a person terminates, or even later, like a year afterwards, so that they've honored their post-employment covenants. And then also an employer can in that way, have the incentive coupled with the potential, leverage to make sure that all those covenants get honored. So that's just like a starting thought in terms of, what we can see as better practices. And with that in mind, Chelsea, I'd like to welcome you to share your thoughts.
Sure, thanks, Mark. Yeah, and just building off what you were mentioning, both in terms of what we've been seeing with our clients, as well as we consistently do broad market research, we continue to see, as you mentioned, Mark, the trend towards, in terms of incentive plan design for at least the long-term plans, a shift towards focusing on those performance plans, performance-based compensation. One interesting thing to think about, though, and we'll get into this in more detail later, is given the changes to 162M, since companies no longer will be able to deduct compensation that's considered performance-based, one outcome could be that companies could start to think, could now shift more towards those time-based awards, such as RSUs. However, given the corporate governance environment that we live and breathe today, I don't think we'll see too much of that shift, so I think companies will still focus on those performance-based plans, but really tailor them to their company's specific situation in terms of, I know, Mark, you mentioned, focusing those on EBITDA measures, maybe more financial measures. We've seen a continued shift towards relative TSR in these types of plans, but it'd be interesting to see how those plans continue to evolve going forward. In terms of plan design for private companies, in our experience, we do see at least private equity portfolio companies tend to prefer stock options still, as it aligns directly with the owners of the firm, given that employees won't realize value until there's an appreciation in company value, which directly aligns them with the private equity company. And then just some other trends besides the LTI design we've been seeing is going back to this corporate governance environment that we live in today. I think clawbacks is a big hot topic now that we've been seeing. So following Wells Fargo, Harvey Weinstein, a lot of companies are starting to assess their company policy, especially either implementing or going back and reviewing their clawbacks to see if it's broad enough and it covers enough of these trigger points to trigger a clawback. Most policies today are triggered by a financial restatement. However, a lot of times companies now are starting to think, should this now encompass a violation of their code of conduct? So should we expand it so that employees will get compensation clawed back for bad behavior or excessive risk-taking? And then the last thing I'll just highlight, I think this is, you might have seen it in the headlines recently, and it's just an interesting case, is really creative compensation programs that companies are implementing that really focus on this pay-for-performance environment that shareholders are striving for. So Elon Musk's pay package at Tesla has recently been quite a big thing in the news because he was granted performance stock options, which give him the ability to earn over $50 billion over the next few years, and quite a large award. However, it is tied to some pretty significant performance criteria. So he is tied to some very significant growth in market value for Tesla. So that's just an interesting thing to keep in mind, and it would be interesting to see if other companies try and mirror this approach or try and think of their own ways to deliver significant value to their executives, but really keeping this pay-for-performance relationship to the highest standard. So Bruce, with that, I'll turn it over to you if you have anything to add.
Thanks, Chelsea. I have seen performance-based, or at least, and both for public and private, where they want to tie the executive to the company, either for a period of time or for performance goals. And so sometimes it's restricted stock. Sometimes I've seen the options, but as Mark pointed out, sometimes that doesn't work so well, but it can work very well to justify it to other shareholders and to the company so that these folks get paid if they perform and meet the goals that are set out in the performance-based program or plan. Also, clawbacks are certainly part of these performance-based programs, and that came from a lot of the clawbacks are now sort of institutionalized based on Dodd-Frank and what happened there, so that if certain measurements are not met, then the clawbacks are available. They're hard sometimes to enforce. I've seen several cases where and there was a banking case, I don't recall the name, where the executive did not meet performance goals, at least according to the company, and so they wanted that executive to repay, I think the number was about $20 million, and the executive wasn't all interested in parting with $20 million, so that lawsuit is out there. And a lot of the deferred compensation plans I draft for these executives, there are goals in some of these deferred compensation programs. Certainly if there's a matching component or a bonus component that gets deferred. And I do see bad actor, and I do encourage bad actor clauses in those deferred compensation plans. And that's based on case Arimony versus United Way, where Arimony had a $2.5 million deferred compensation plan, and the company, United Way, did not want to pay $2.5 because Arimony was unceremoniously fired because I think it was fraud or some felony. So he got 7 years of federal subsidized housing somewhere in the United States, and then sued United Way to get paid on the $2.5 million. And the court said that based on the history of that plan, where the company, United Way, said, you know, we ought to have a bad act, we ought to have, you know, the plan here, and we put you two, which they normally did, it was the vice chair of the directors or some person, and he was charged with drafting this plan. And at first they had a bad actor provision in the plan as a draft that was circulated, and then the final version did not have a bad actor clause. So the judge said that United Way thought about it, thought better of it, and didn't put it in the final agreement, so Arimony wins. So he got paid $2.5 million. Probably got sued by United Way for something else. But so in any of these deferred compensation arrangements, I encourage the employers to think very hard about what they want to encourage in their behavior of their executive and what they want to discourage. So have bad actor clauses, maybe a clawback, and then maybe the goals specifically set out so there's no disagreement, which sometimes happens, like this clawback provision on this banker, that there could be a disagreement as to whether or not the goals and performance awards were met. So those are the kinds of things that I like to see in plans and programs and what I have seen. And so that's my best advice on improving any of these bonus or performance-based awards. Mark, anything else?
No, I think a good time to move to the next frame. I will say, you know, agreeing with what you just heard in terms of bad actor clauses, with the invite for today, you, I believe, received an article titled "Hitting Workplace Harassers Where It Hurts." And echoing what Bruce said, that article that I put together at the end of last year goes into just the issues in terms of, you know, our employers appropriately and thoroughly, you know, defining what is cause, and as well as not just defining it but in a way that embraces the types of conduct they want, but also to figure out, well, what's at stake, because look-back provisions can put, you know, it's one thing to forfeit current compensation, but when you have a bad actor like Bruce mentioned in the Arimony case, you often want to have more at stake than just the current compensation. So there's a lot there that can be considered. And I think that kind of is a good introduction to our new year, new LTIP discussion, because in my experience, most plans that companies have evolved over time, and there are often, you know, significant areas for improving them, whether it's public or private companies. Why would you do it this year? Well, one reason is that, as a general rule, when you go to stockholders for approval of any action, you know, you want to go when the stockholders are happy and feeling favorably inclined to the company and toward its management. Probably there's nothing better than to go to stockholders when they've had several years of upmarket stock appreciation, which to me describes where we are now. So I think a threshold thought here in terms of timing the shareholder mood is that if a company is looking at its equity award plans and needing stockholder approval or wanting to get it voluntarily in order to get a buy-in from their stockholders, if they have less than a few years of award of shares available under their plan to cover a few years, now is a good year to go ahead and put together a plan. You know, certainly one way to approach it is to just take an old plan, the 2007 LTIP or equity plan, and just make it the 2018 version. I think that actually, though, aside from just getting more shares or more flexibility for awards, there are some significant improvements that companies can be considering, and there is a second attachment with your material today, an article titled New Year, New Stock Plan, which goes into a number of these considerations. But just to give you a feel for it, a few that come to my mind that are worthwhile to address in any new plan would be expanding types of awards to include or to consider offering profits interests. I think of the holy grail of executive comp planning being, can we somehow give out incentives to executives and do so in a manner that avoids ordinary income and gives potential for capital gain treatment. And profits interests do have that potential. There's a lot of complexity to them from both a design side and an accounting and tax administrative side, but in many cases that can be worthwhile to consider, whether it's for a separate subsidiary or for a company on a broader basis. So profits interests are something to think of in terms of improving plans. Public companies can now eliminate a lot of the 162M baggage. We'll talk about that more going forward. Other changes that I think are worthwhile to consider: international implications, especially privacy rules. Those are very smart to address in a plan document. And in my experience, companies are being international in their scope of stock awards as well as other types of plans on an escalating basis. Forfeitures for competition in terms of what we've talked about to encourage honoring of non-competes, non-solicits, trade secret protections, worthwhile to include. And then the last thing I'll mention before turning it over to others is litigation protections. There is a laundry list of things that employers can put in a non-qualified plan or a stock plan that will minimize the risk of claims or adverse outcomes for those who participate in the plans. Some of them are things like requiring that claims be asserted promptly, like within 3 months after an individual has notice of what they're complaining about, and then having an exhaustion of remedies through the plan be required. There are cases out there, several of them, that not only approve those types of what are called internal statutes of limitations, but you can also, if 21 years in some states is the limitations period for breach of contract, a plan can actually say, despite whatever the regular state statute of limitations is, for our plan, anyone getting these awards is limited to a period of 1 year or 2 years. So these types of provisions can be woven into a plan, and they're generally not objectionable, but they greatly increase the ability of an employer to control litigation. Another one that's a little more controversial but on the radar screen to consider is forum selection. Do you want to have all the litigation occur in one forum? There's a Supreme Court case enforcing that one. So with those as a few of the items that are worth considering, in terms of new plans or restated plans, I'll turn it back to Chelsea.
Thanks, Mark. So the first item I wanted to cover, and you mentioned this, Mark, but just to build off of the regulation change with the Tax Act, and since there have been changes to 162M, companies are technically no longer required to include some of the items that they have needed to include in the past in their plan documents. So, for example, what measures they would be using for performance awards, any individual limits on the awards. However, we've seen that there may be some indication that shareholders, potentially shareholder advisory groups such as ISS and Glass Lewis, may still want to see these in the stock plans for companies. So as you're going back and amending your stock plans or making a new stock plan, just consider potentially if there any reason not to take them out, it might be worth considering just keeping these sections in going forward. And then just building on that, another thing to consider as you're going back with a new stock plan is ISS recently submitted their new equity plan scorecard. guidelines, which is what they will use to assess the stock plan. And so they've made a few changes this year in terms of their scoring system. So just something to consider as you're adding these new really requirements in your stock plan. So they changed their minimum vesting to, if you implement a minimum vesting of at least 3 years, you'll get full points, as well as making some changes to their post-vesting holding requirements. In the past, they've given partial points on if there was a holding requirement until stock ownership guidelines are met, but that's no longer the case. They'll only give you credit if it's for at least 1 year, no matter the circumstance. And they've also made some changes to their change of control vesting, so that's just one point to continue to keep in mind. Excuse me, and then the last point I just wanted to raise is, we might get into this a little bit later, but adding a director compensation limit to your stock plan, which we've seen an increasing trend over the past few years. As companies amend their plans and go back for approval, it may be worth considering just adding a director compensation limit. And this can be structured both in terms of a total compensation limit or just an equity limit. We've seen most companies tend toward a dollar value of a total compensation limit. And as we've seen just in some litigation examples, having an upper limit may not protect against all litigation, but it's becoming best practice that it could be something really good to consider as you're putting these plans up for approval. Bruce, I'm going to turn it over to you now.
Thanks, Chelsea. The Dodd-Frank, and I agree with all of that, the Dodd-Frank Act is very favorable to director compensation limits and those kinds of things under Dodd-Frank. The shareholders would get a right to vote on the compensation every year, every other year, or every 3 years. Then the shareholders could vote on whether or not they want to review those compensation arrangements. So having those limits in these director plans, I think, is worth doing. It's certainly consistent with what Dodd-Frank has to say about that. But also, in these programs, it's worthwhile to consider how these deferred compensation arrangements are structured and what flexibility the employer has in terms of that compensation. So in addition to adding the bad actor clauses and things like that, it's important to look at the amendment provisions and what authority the employer has. There are a couple of cases out there where, in one, it's Tate versus Chiquita Brands, where the employer decided to change the interest on the accrual of the benefit under the deferred compensation plan. And of course, that affected everybody's deferred compensation because it went from somewhere around 10, 12% down to 5% or some. It was a significant change in the accrual. So the employee sued and said, you know, under the unilateral contract doctrine or theory, that once the employee performs under the terms of the plan, so the employee was an executive, the employee worked for the employer, the employee did everything that the employer required under the terms of the plan. So when the employee was affected by that change, the employee sued and said, I, the employee, performed under the terms of the contract, the deferred compensation arrangement. So now the employer has to perform in accordance with the terms of that contract as well. And since the employer did not do that under the terms of the plan, because the plan wasn't drafted that way for the employer to have the ability to make that change, the employee won. There's another case on that very same issue under the unilateral contract theory where it was Kemmermer versus ICI Americas, where Kemmermer and another employee worked for the company, retired, elected to have 10 annual installment payments of the deferred compensation, and so then that was the structure, 10 annual installments. After about 2 years, the employer decided that it did not want to continue the plan. The administration cost was too much, and so they got an actuarial determination of that 10-year annual installments and paid these employees the actuarial equivalent of that in a lump sum after a couple of years of payments. Kemmerer sued and said, can't do that because I, the employee, performed and the employer did not have the ability to make that change because the amendment and termination provisions were not that clear or that broad, so the employees won. And the court said that the contract had to be performed, but no damages. The court didn't think the tax consequence, I guess, was that important, and taxes are the price we pay for a civilized society. So that was that. But what these plans should have is something that will conform to 409 Cap A and say that the plan can be terminated at any time by the employer, and upon a termination, then we can't pay out during the first 12 months, but we have to pay out within the first 24 months. So what the employers need to have is a good amendment provision, a good termination provision to give it the authority to make any changes that it might need to make in the future. So again, the employer in thinking about these deferred compensation arrangements need to be very thoughtful about what it looks like now, what it looks like later. So, and I also agree with Mark when he mentioned profits interest. Depending upon the employer structure and what the employer needs to do, that has very favorable tax consequences, and very worthwhile thinking about that and thinking that through. They are complicated, but very worthwhile if it fits within the employer structure because of the very favorable tax consequences. And I guess with that, I'll turn it back over to you, Mark.
Yeah, great. One thing Bruce mentioned there, because the emphasis on having the good amendment and termination provision made me think of a merger and acquisition context. There was, if you all remember back, probably about 15 years, AT&T Wireless sold out, and at the time of the sale, I think their stock had dropped to less than 20 cents a share, and there were tons of out-of-the-money stock options. And in the deal, they basically canceled the options because, you know, if the exercise price is $23 and the deal price is 23 cents, who would think that would be worth anything? But unfortunately, in that situation, the plan did not allow a unilateral cash out of the options, and years later, the option holders who were, you know, canceled out in the deal ended up recovering $23 million in damages. Interesting strategy that you can follow there. Suppose a plan doesn't give that type of a right currently, but the plan is amended. In a new stock award, you can have a provision that says anyone who accepts the new award is agreeing to the change to the plan, and one of the plan changes being, you know, like an employer right to cash out on out-of-the-money awards in a deal. So anyway, I mentioned that just because there are a lot of things that we can do to improve plans and to anticipate and avoid problems. Speaking of the avoidance of problems, now we're ready for the next frame, and Chelsea's going to talk about handling investors and ISS, Glass Lewis, and other strategies that come with that.
Thanks, Mark. Yeah, so in terms of, I'm just going to cover off on a few different points that I think is helpful to be aware of in terms of the shareholder advisory firms, ISS and Glass Lewis. So I think the biggest change for ISS this year comes with their policy updates. And as many of you may be familiar with, in the past, how, as it relates to stay on pay and how ISS assesses public companies' executive compensation programs, they've typically used 3 quantitative tests to assess the program in order to assess if it is a pay-for-performance program. And in the past, they've been 3 tests that have incorporated both absolute and relative pay-for-performance, with performance being defined exclusively by stock price performance, defined by total shareholder return, or TSR. And going forward, what's interesting is they'll still keep those 3 core tests, but there's a secondary screen that they'll now do, which is again, a relative pay for performance test, but with performance now defined by financial metrics. So they'll incorporate 3 to 4 financial metrics, which depends on the company's industry, including EBITDA growth and some return measures such as ROIC, ROE, or ROA. And this is a sort of a secondary screen, which only kicks in if a company's score based on those first 3 stock price performance tests fall in a certain range. And that can trigger the recommendation going from a low to medium concern or a medium to low concern. However, if a company scores a high concern on that first pay for performance screen, the financial performance assessment test, which they're calling the FPA, will not come into play, and they'll get that high concern level. So I think that's one of the biggest changes for ISS. For ISS and Glass Lewis, another thing that just to note is with proxies coming out, the CEO pay ratio is now being disclosed for the first time. But both ISS and Glass Lewis have both said they'll pick up this information, but they won't use it in their assessment at all. And then other than that, the only other items on ISS and Glass Lewis that I wanted to raise are some more regulatory news. So at the end of 2017, I thought it was interesting, there's an act that actually was passed in the House of Representatives and now sits in the Senate called the Corporate Governance Reform and Transparency Act. And what this act is, the intent of this act is to actually improve the quality of proxy advisors by fostering more accountability and transparency and responsiveness in terms of their practices. And some of the items that the bill includes is that these proxy advisors will have to submit their recommendations to companies prior to publishing their reports. They'll have to make sure all their methodologies are public, and they'll have to register with the SEC. So that's just an interesting bill that's out there right now, and it'll be interesting to see where that goes and if it's passed, how that'll change ISS and Glass Lewis practices. And then one just final news update as well on ISS is that they recently bought this company called EVA Dimensions, which focuses on EVA, or economic value added. And so there's some speculation that with this new company under their ownership, there might be some more changes to their pay for performance tests going forward, potentially adding EVA as another performance metric. So that's really a summary of ISS and Glass Lewis policy changes for the upcoming year. And so the next thing I wanted to cover is just how these changes will affect plan design. So one thing, now that ISS is adding more financial focus on how they define performance, I know in the past we've seen a lot of companies sort of shift towards, I mentioned this before, TSR to define their performance in their long-term plans especially, which has in the past correlated with how ISS has defined performance. So we may expect to see companies now maybe shift a little bit away from TSR, or maybe just add more metrics in addition to TSR. We've seen an uptick in use of return measures in long-term plans recently, such as ROIC. So balancing a stock price measure with a return measure to make sure that investments are really creating value for the company. And then the other thing for plan design is now with 162M, there's no longer a strict rule around that you must use quantitative, measurable performance metrics. So we've actually, in the past few years, seen companies shift towards incorporating more strategic measures in their incentive plans, but in the past, they've had to have some sort of umbrella approach so that their plans were still tax deductible. But now it gets a lot simpler since 162M has changed so much. So we're expecting to see companies continue to really assess what measures make sense from their business perspective incorporating any strategic or more financial measures and not having to do this additional administrative step of this umbrella plan due to 162M. And then lastly, I know we have the stop plan on the page, so why should private companies care about all this? So I would say there are a couple different points. So one, we see a lot of our clients adopt best practices or try and just know what the public market is doing for a couple different reasons. One, if there's ever an instance that they're going to IPO, a lot of companies like to start putting these practices in place before they IPO, just so they're ready once they do become a public company. But I think also, and more importantly, private companies recruit and attract talent away from public companies all the time. So for the fact that they want to make sure their comp programs are competitive to attract and retain their key talent, I think it's helpful to know what the public market is doing and make any changes to the compensation programs from a competitiveness standpoint. So with that, Bruce, I'll turn it over to you.
Thanks, Chelsea. I'd like to focus a little bit on this plan design, qualitative and quantitative. The United States Government Accountability Office is doing an investigation of these non-qualified deferred compensation plans at the request of Senator Bernie Sanders. So I've met with them. There's a team led by David Lynn out of Chicago and David Reed out of San Francisco. There's one other person out of Washington, D.C., and I've met with them maybe 3 or 4 times to discuss these deferred compensation plans, how they work, who benefits, how valuable they might be or might not be to companies. And that's why we've been stressing that if the plan is an unfunded plan for a select group of management or highly compensated employees, then it's a deferred compensation plan for a certain select group. And the Department of Labor hasn't really commented too much on this. They've done so in amicus briefs, but it's under 90-14A, one of the real only pronouncements by the Department of Labor. The Department of Labor, think that the plan should be for this group that, by virtue of their position and authority, can influence or negotiate their deferred compensation benefits, and they would not need the protections of ERISA. So these plans, refer to them as top hat plans, they don't have to satisfy Part 2, participation and investing, Part 3 on funding, and Part 4 on fiduciary responsibilities. So they're not subject, these plans are not subject to those requirements of ERISA. But since the department really hasn't defined what a select group is, who's management, and who's highly compensated, the courts have sort of filled in and try to fill in this void. One of the key cases that you want to look at is Demery versus Extabank pension plan, Plan B, where it was for vice presidents and above of this banking enterprise. And while we all know that almost everybody at a bank is a vice president, they also had a compensation the court looked at the compensation of the vice presidents and above, and at their compensation level, they were significantly higher at that level than the next level of employees. So the court looked at whether they were in management and whether they are highly compensated, and then the next metric was, is it a select group? The group that was benefiting was a group that could benefit about 15.37% of the employees of the company. And the court said 15.37% is high, maybe as high as it should be, but it still defined a select group. The other case out there that said not a select group is Nationwide, and in Nationwide, they benefited nearly 18% of the workforce. And the court in that case said, when you benefit almost a fifth of the workforce, that we don't think is a select group. Then one case that's interesting for highly compensated is Simpson versus, I think it was Arthur Anderson. It was a big accounting firm. And Simpson was in the plan, but wanted to have the plan be subject to ERISA because I think he was terminated and didn't get the benefit of ERISA. So he sued saying it should have been subject to ERISA because it was never a top hat plan. And the court looked at his compensation, and it was somewhere north of $180,000. So he got paid pretty well, but the court said that other partners or principals of that accounting firm were making about $800,000. And that was significantly greater than Simpson and his $180,000. So the court said that he was not a highly compensated person, and that plan should be subject to ERISA. So you want to look at these metrics very carefully because the government, the United States Government Accountability Office, is doing just that. And I did give David my most recent published book on non-qualified deferred compensation plans, and he is reading it. Not that everybody does, but he is. And so he asks very good questions. And I think their investigation is going on for a little while longer. He said that if I wanted to talk more with them, they're certainly willing to do that for several months here in 2018. So that's why I say pay attention to these metrics. The plan design is important. And so I think that's one thing employers ought to consider very carefully. And with that, I'll turn it back over to you, Mark.
Yeah, two thoughts for private companies. Bruce hit the nail on the head, I think, in terms of I've had a lot of private companies ask about deferred compensation plans and think that it made sense and, you know, to defer payouts and then go forward a little too enthusiastically and to include too big a group of people. So the select group is huge to keep in mind. The other thing I'd mention on private company side is building from what Chelsea said. You know, we talk a lot about ISS and Glass Lewis and their standards for what are best practices and worst or poor practices. I think that the lesson I've kind of observed over many years of watching their you know, statements in both respects is that it makes it important for a company to avoid what you hear referred to as irritants. That if you have an executive compensation program and it's loaded up with country club memberships and other types of, or like tax gross-ups, even though there are situations where tax gross-ups, such as for golden parachute payments, can make sense, and I do think it's important to keep in mind that sometimes what could be considered a poor practice makes a lot of sense for a company to pursue. Nevertheless, trying to recognize what is an irritant, what could get you in trouble with stockholders, and then try to avoid those types of practices, even in the private company context, I think it's really important because there's no reason to have a practice other than that doesn't have a significant corporate impact that will expose you to uncomfortable questions from stockholders. Now, with that in mind, let's go forward to the next frame because Bruce is going to be talking there about a couple of the Tax Cut and Jobs Act changes.
Sure. So Section 83I is new to the Internal Revenue Code, and that section for employees of private companies who are granted stock options or restricted stock units, they can elect to defer the income taxation for up to 5 years from the exercise or the vesting date. So I think that's in addition to the sort of the 83B elections where companies could elect to be taxed on it. Currently thinking that there'll be an increase in the value of the company so that the individuals will pay the lowest tax possible because they'll pay it currently. Now the downside on that is if you pay the tax currently and the value of the company goes below that, you've lost on the bet. And so here again, you could lose on the bet depending upon what happens 5 years later. But the thinking is the 83I election can be very, very valuable. But it is limited. So a company has to be a privately held company. There has to be a written plan that provides stock options or restricted stock units to acquire this qualified stock. And the qualified stock is a stock that can be deferred out to 5 years. But the key is at least 80% of the company's employees have to be eligible to participate. And that may really limit this 83I election because companies might not have that kind of a broad-based plan. They just might not. And so that's another issue. And then you have to provide some stock rights, and they're very specific. It's under 423B5, but it's just some stock rights that would otherwise be available to every other shareholder. So that's another factor that might be limiting on what this Section 83I can do. Now, employees that cannot participate in this would be a 1% owner at any time during the calendar year or during the 10 preceding calendar years, has been at any time the chief executive officer or chief financial officer or an individual acting in either capacity, a spouse, child, grandchild, parent, and who knows who else, but they try to sweep in just about anybody that could be related. They don't get to the grandparents, but probably, you know, it's very broad on who cannot participate. Then one of the 4 highest compensated officers of the company for the year and for any of the 10 preceding taxable years. So you have to be pretty careful on who cannot participate, which also might be a limiting factor, because employers that have a broad-based plan like that usually want it for everybody, and you have a lot of folks here that can't participate, and you have to pay attention to that, because if they do participate, then you have a problem under Section 83I. So I guess here's 162M, but before I do that, any other comments, Mark, Chelsea, on what you think about 83I?
Oh, I'll just mention quickly, Bruce, I agree with you. I don't see 83I as being something that private companies would want to pursue for the reasons you're stating. I think that in general you can have 83B elections and other vehicles through either options or RSUs or restricted stock that give, to me, the key people to you know, get involved in sophisticated arrangements are the executives, and I can't see getting rank and file employees involved in this level of tax deferral and the risks and all of that. So that's my own view on 83I probably being something that was put in there at the time they were thinking of 409B, and maybe it's a remnant from it, but it doesn't seem to me to have much application personally from my perspective.
Yep, I agree. Any thoughts, Chelsea, before we go on to 162M?
Nope, I think you guys covered it all.
All right, we like to be thorough. So we're glad we did that. Now 162M, Chelsea talked about this earlier, and so it does make changes in who the covered employee is for participation, performance-based pay, which now is going to be included as compensation under 162M. There's a grandfather provision in here that is important that could be used. The Act includes a transition rule that would allow companies to deduct compensation paid under a written binding contract in effect on November 2, 2017, if the terms of the contract are not modified in any material way. So November 2 is kind of an operative date if there is a plan in place. Then you might not want to modify it because you might be able to take take advantage of this grandfathering provision. So who is a covered employee? The definition of a covered employee is expanded to cover anyone who is in the CEO, Chief Executive Officer, or the Chief Financial Officer at any time during the tax year and the 3 highest paid officers during the year. And once you're a covered employee after 2016, you're a covered employee. So you're already there. Then what compensation is excluded? Another key change, the performance-based compensation and commission-based compensation exceptions to the $1 million compensation limit have been eliminated. So annual bonus payments, performance-based awards, and non-qualified options are now subject to the Section 162M limit. So that's important. That'll get these folks to the $1 million pretty fast. So before we leave that, but maybe one other comment on this is the rates under the tax code now have been reduced. So maybe they're willing to not care that much about 162M limits and pay out the money, understanding that they'll be taxed at a lower rate, at least now and for a little while. So that might be a mitigating factor for 162M. Any other thoughts, comments, Mark, Chelsea?
Yeah, I would just add, I think the changes to 162M are pretty substantial in terms of plan design. As I mentioned before, a lot of administrative burdens have been sort of relieved with the flexibility to use more strategic measures and not have to do the whole administrative burden of putting in an umbrella plan. I think that's the biggest change, as well as the covered employees. Once you're a covered employee, to always be a covered employee. So even severance payments to employees that are leaving, those are all going to be under this new 162M, which is just all things to keep in mind. So I think those are the two key points, and just to see how companies take these new changes and start to weave them into their compensation programs for 18 and beyond.
Yeah,
Bruce, I'll just mention one thing, which is I've worked with the American Benefits Council and the working group there on issues related to negative discretion, because you mentioned at the start the grandfathering rule, and 162M plans, this is only relevant for the public companies, but when a plan does have negative discretion, which means if the performance goal formula pans out and at the end of 2018 an amount like $1 million is payable, then there could be discretion to pay a lower amount. One issue is whether that destroys grandfathering if that discretion is present or exercised. So if we have anyone on the call that wants more information about that, we can provide it separately. But I know we're toward the end of our time, so I'm going to switch over. If we can go to the director comp, I think that's worth a quick mention, which we can do in a minute, and then we'll have just a little bit of time for final remarks. But in director compensation, if you look at the New Year, New Stock Plan article, and by the way, anyone who hasn't received those or seen them available, we are going to send them out after this call as an attachment to an email to everyone. But in the New Year, New Stock Plan article, there's a significant discussion of director compensation and adding limits. The reason to consider it comes from Delaware litigation, where boards are being sued for paying excessive compensation. One reason that's happening is because new SEC disclosure rules require, for the last several years, disclosures of total compensation for directors, and as a result, it's easier to make peer group comparisons. Under Delaware law, there used to be a rule up until the end of last year that said if shareholders approve a reasonable or meaningful, actually it's a meaningful limit on director compensation, then any litigation gets reviewed under a very deferential business judgment rule. When that's not available and a board gets sued for paying excessive compensation, then a board, if they can't show business judgment rule deference, the board has to show not only that they engaged in a prudent process, which would include survey data and other things, but also that the overall decision they've made is reasonable. So essentially, any board that's paying what could be arguably above market or significantly above market is at risk of litigation. But the suggestion is in this article, and that we would have you consider, is in a new stock plan or other plan that gets stockholder approval, consider having a real limit on director compensation and just lock it in. And if that gets approved, either for all compensation or, to me, a lesser degree of protection, but nevertheless worth considering, say just stock awards, then the company then, by getting stockholder approval, gets great deference and probably falls off the radar screen for this type of litigation. So it's something that's worth considering at public and private companies, because I think you're going to see many headlines of boards being sued because they're vulnerable anytime they're paying above what survey data would show to be a median or middle level for their industry. With that, we're at the top of the hour, And I'll welcome Chelsea to go first with any final comments, and then we'll go to Bruce and we'll finish it up.
Sounds good. Thanks, Mark. And the one point I would just add on the director compensation point is just to note that one other fact on ISS is that they did have disclosed that beginning in 2019, so not this year but next year, they're going to begin looking at excessive director compensation as well, and will recommend against for any board or committee members who are involved with setting board of director pay if they deem it to be excessive. So just another point to keep in mind. So then just some final thoughts. I think there's just been a lot of changes in the past few months in terms of the compensation environment with the Tax Act, changes to ISS and Glass-Lewis, the CEO pay ratio starting to be disclosed. I think all those create an exciting environment and an opportunity for companies to continue to assess their incentive plan design and make any changes that they think make sense going forward. Bruce?
I agree with all of that, and since we are at the top of the hour, I think we should, I guess, be done. Mark, do you want to close it out?
I can close out by thanking anyone who's called in, because we had a nice group, and especially thanking Bruce and Chelsea, and I'm sure that we'll have a future installment of this dialogue, and we hope it was valuable for those who called in today. So thanks, everyone. Good day.
Thanks.
Thank you, everyone.
Bye-bye.